You attended a seminar that the defendant's company hosted, which specialized in getting people out of their timeshares.
Right.
Yes.
You sign a contract. You paid about $3,000, $29.95. In this contract, it said you can cancel within 3 days.
Yes.
And a couple of days later, you're like, you know what? We can actually sell our timeshare ourselves.
Right.
So you reach out to the defendant. You don't hear anything. You follow up, and they say, we didn't get your 3-day notice. We're not going to give you any money back. And that's why you're suing him, because
That's
you
right.
claim that you're now entitled to a refund of the monies that you paid. Mr. Rickless, you say that the plaintiffs never canceled within that 3 days. Mr. Rickless, what sort of service do you provide? How do you help people divest?
Basically, we look at the property that they own, and we find out what their maintenance fee is, how they're using it, and in many cases, we find that they're not using it, and the maintenance fees have continually gone up. The children don't want it, and we assist them to divest them out of that obligation.
Okay. May 14th, they attend your seminar. Why do you sign up, and then why do you cancel so quickly?
Well, the seminar painted a picture of difficulty getting rid of timeshares, that there were too many on the market. So we hedged our bet. Prior to going to the seminar, we had already contracted to sell the timeshare. There was a TLS timeshare person that we had negotiated with, and they said they could sell the timeshare.
So this is a third-party company that was actually able to sell your timeshare, having nothing to do with the defendant.
Exactly. So in this particular case at the seminar, the picture was painted that the impossibility was going to occur. So we told the individual that we talked to about the other contract. They encouraged us to hedge your bet.
But then 2 days later, according to your complaint, you're like, hey, it's not so hard to divest.
Right.
So I am going to direct your attention and Mr. Rickless's attention to, it appears to be an email. It's dated May 16th that says, Dear Sean, this is to notify you of our decision to cancel the agreement. And then you give a number of reasons for the cancellation. The next page after that email, I see a certified mail receipt. So, Mr. Rickless, ball's in your court. Why didn't you cancel?
We did not get notice. Our procedure is pretty simple. After they purchase, and when they purchased on the 14th, we do a follow-up phone call to confirm with them that everything is good, that they're happy, and there are no problems. All those notes are in our file. There was nothing and no discussion.
But they've presented evidence that they provided notice of cancellation within 2 days.
But also, if you read the contract, it indicates that they are also then supposed to call.
I did.
After.
It's your position that because they didn't call in addition to doing those 2 other things, that the cancellation wasn't valid?
Because we did not get notified within the 3 days.
Judge Domingo?
Can you tell me, do you have evidence of a phone call?
I don't have evidence of a phone call, but we did make the phone call, email, and the certified mail.
Didn't you say your company reaches out within a couple of days?
Right.
Yes.
And did they reach out to the plaintiffs?
We contacted the plaintiff on the 15th.
Did they reach out to you?
No.
We've been doing this for 7 years. We have a real strong procedure. Not only does our administration reach out to them, but also if there's any issues, it's always brought to our attention.
But why would he want to not comply with the rules? They both didn't want the timeshare.